Charlie here with Megan, and we're trial attorneys, and we're going to go on the record here.
We are on the record, and so today on the record we are talking about records. In other words, what do we do in court and what is written down? What gets written down? What happens if it's not written down?
What does get written down?
We'll start with if you're in trial, what gets written down?
Preferably everything. You need everything written down, in my opinion, and you're usually going to have a court reporter. You can't have a trial without a judge, a court reporter. You need one attorney on one side and one attorney on the other, but as important as anybody is the person that's taking it down, or they're talking into their soundproof little thing here. I don't know.
The little,
it's more
device.
Modern, yeah. You see them there, and I know they're talking. You can't hear them though.
Now, for some reason, we have the ability to put a camera in there and a microphone and hypothetically get everything on video, but we don't do that. Maybe it's the court reporter lobby. Who knows?
You got to have a certified transcript.
You do. You have to have a certified transcript too.
And when I hit the transcribe what we're saying here, although it's going to be great and highly accurate compared to most of the things, it's not going to be like a court reporter's certified transcript, because they can go back and they can listen to their recordings, and they want to get it right. You want to have an accurate account of what happened in court.
Right. And so if we're talking about at the trial stage, there are certain parts of it that, free of cost, you don't have to pay for it at all. The court reporter is going to make sure it's going to get taken down, and the judge as well. There are other parts of a trial that are optional. In other words, it doesn't necessarily have to be
They could be off
graded.
the record.
Right. You don't have to have someone kind of saying it to themselves or typing it out or writing it down. And those parts of the trial include?
Really, if I'm answering the question, all the parts that you possibly can get on the record. A lot of times you see the attorneys go up and talk to the judge about something, and the court reporter is excluded. And a lot of times I like to go back and make sure that we go back on the record and discuss what it was, because otherwise it'll just say a discussion was had at the judge's bench, and they don't know what was said. Some of the biggest decisions are made in those times, and so preferably everything. And it's not always an easy task as an attorney that's trying to make a good record to get them to put everything down.
And talk a little bit more about that, Charlie.
It just there's just an aversion to it, and it disrupts the proceedings sometimes. You can just wanting to not have to. Sometimes you have to excuse the jury to put certain things on the record. This is what just happened, and you want to talk about it freely on the record, but some things can't be said in front of the jury. That's one of the biggest, I think, disruptions. And then just judges in general, sometimes they like to talk. They talk differently. People talk differently when they're on the record and when they're off the record. And
judges are aware of it too. And then there are certain parts of a trial that, unless your attorney, I think, affirmatively asks, or the judge just wants to, are not going to be taken down at all.
Like voir dire, opening, closing, but you want it all taken down. We always ask to have it all taken down, even if we get a dirty look from